Hi guys, and welcome to the last episode on the law on security and credit transactions. Today we'll talk about the contract of chattel mortgage. So if you like my videos and you want to see more, please hit the subscribe button. And please remember that this is only for educational or informative purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So what is a contract of chattel mortgage? It is one where personal property or movable property is recorded in the chattel mortgage register as security for the performance of an obligation. Okay, so it's an accessory contract, meaning it cannot exist without the existence of a principal obligation. In fact, it exists to secure the fulfillment of that principal obligation. It is likewise a formal contract. Okay? Meaning there must be compliance with the formalities of law in order for it to be valid. What is this requirement? It must be registered in the chattel mortgage register. However, please take note that while it is required for validity, in case the registration requirement is not complied with, meaning the parties fail to register the chattel mortgage, then it will still be binding between the mortgagor and the mortgagee. This is according to Act 1508, okay, which must be read in conjunction with the law on chattel mortgage under the Civil Code. Okay? Now, this registration requirement acts as a notice requirement to third persons, meaning it creates a real right which is enforceable against the whole world without a definite passive subject. Okay? Why? It operates as notice to third persons that the thing is subject to a chattel mortgage. Okay? Without registration, it will not bind third parties. However, again, according to 15.8, it will still be binding between the mortgagor and the mortgagee. Okay? So again, as a general rule, the registration must be complied with in order for the contract to be valid. But even if the registration is not complied with, it will still be binding on the mortgagor and mortgagee. It will simply not bind third persons. Okay? A chattel mortgage is also a unilateral contract, no? Meaning it creates an obligation on the part of the creditor to return the thing to the debtor in case the principal obligation has been fulfilled. What is the object of a chattel mortgage? As a general rule, it covers only personal or movable properties. Okay? However, the parties may so treat a real property as personal property for the purpose of subjecting it to a chattel mortgage, provided first, they agree, and second, no third persons are prejudiced. Absent the two, it can only cover personal properties. Okay? Now, let's talk about the requirement of registration. Again, the purpose of registration is to create a real right which can be enforced against the whole world and third persons. If registration is not complied with, the chattel mortgage is still binding on the mortgagor and the mortgagee but will not bind third persons. So for registration to be valid, first, the personal property must be registered in the chattel mortgage register of the province where the mortgagor resides. Okay? So, that is the first requirement, where the mortgagor resides. What if the thing is situated in a province outside of where the mortgagor resides? Then what the law requires is the personal property must be registered in the chattel mortgage registry where the mortgagor resides and where the property is situated. Okay? There are two requirements of registration. One, where the mortgagor resides, and two, where the personal property is situated. Okay? That is if the thing is situated in a different province from where the mortgagor resides. Okay? But if they're in the same place, then registration should only be where the mortgagor resides. Let's go to the third requirement. We have what is called an affidavit of good faith. Okay? What is this affidavit of good faith? It is one where the parties swear that the chattel mortgage is entered into for the purpose of securing this particular obligation and no other. Okay? And they also swear that the obligation is a just and valid obligation and not one entered into for fraud. Okay? So what's the purpose of this affidavit of good faith? It merely confers a preferred status upon the mortgage, meaning the creditor holding a chattel mortgage will be preferred against other creditors. So what is the effect of the absence of an affidavit of good faith? Okay? It will just remove the preferred status. It will not affect the validity. It will not affect its binding effect on third persons, because an affidavit of good faith is not required for the validity of the chattel mortgage, and it is not required to bind third persons because it is mere registration that is necessary for validity and to bind third persons, not the affidavit of good faith. Okay? Again, the affidavit of good faith is only to accord the chattel mortgage a preferred status. Okay? Now, what kinds of obligations can a chattel mortgage cover? Okay? A chattel mortgage can only cover obligations which are existing at the time that chattel mortgage is created. Okay? Now, what if the parties stipulate that future advances on credit will also be subject to the chattel mortgage as a security, no? In that case, they will take effect only from the moment those advances are made. Okay? They will not retroact to the time that the chattel mortgage was created. Okay? So, as a general rule, a chattel mortgage can only cover obligations which are existing. Okay? Now, what if the debtor fails to fulfill the principal obligation? Can the creditor become the automatic owner of the thing subject of the chattel mortgage? No. Okay? Why? Because this is the prohibition under Pactum Commissorium, no? So what is a Pactum Commissorium? Let's review. A Pactum Commissorium is a stipulation which provides for the automatic appropriation of ownership by the creditor of the thing in case of non-payment by the debtor of the principal obligation at maturity. This stipulation is void. Why? Because the creditor cannot become the automatic owner. There must be an intervening step or process before the creditor owns the thing. Okay? But please remember that only the stipulation is void. Okay? We will just delete that stipulation or treat it as not written, but the chattel mortgage itself, it is still valid, it still subsists. Only the stipulation will be void. Okay? So what is the remedy of the creditor in case the debtor does not fulfill the principal obligation? We have what is called foreclosure. Okay? Under Act 1508, foreclosure must be made through a public auction, no? The foreclosure sale must be made through a public auction. However, the parties may stipulate that the thing will be sold through a private sale. Okay? So let's talk about this public auction, no? The thing may be sold in case of foreclosure in 30 days, within 30 days from the time of non-payment of the obligation. Okay? There must be notice to the mortgagor at least 10 days prior to the sale, and said notice must be posted in the public places of the province at least 10 days prior to the sale as well. Okay? Now, the mortgagor and the subsequent mortgagees or any other creditor may exercise what is called the equity of redemption. What is this? These persons that I mentioned can pay off the principal obligation at any time during the period before the sale of the thing foreclosed. Okay? That is the only period before the sale of the thing foreclosed. Okay? And what is the effect? If they're able to pay, then they will be subrogated to the rights of the mortgagee, and they themselves can foreclose the thing subject to the requirements of the law. Okay? So now let's say there is a purchaser at the public auction, no? What will the proceeds of the sale be applied to? First, we have the costs and expenses of keeping of the thing as well as the sale thereof, no? Second, that is the only time we apply the proceeds to the principal obligation itself. Then if there is any left over, we will apply it now to the claims of the subsequent mortgagees and other creditors. And if there is any more left, it will go now to the mortgagor. In other words, the mortgagor or the debtor is entitled to the excess. Okay? This is different from the rule on pledge. We'll distinguish that later, okay? Now, what if after the sale there is a deficiency, meaning the creditor was not able to receive full payment for the principal obligation? Can he still go after the debtor? Yes. The creditor may institute an action to collect the deficiency or yung kulang from the debtor unless it falls under the recto law, which is found in paragraph 3 of Article 1484 of the Civil Code. Please remember, under the recto law, which covers a sale of personal property in installments, the thing subject of that sale can be subjected to a chattel mortgage which may be foreclosed. Okay? But in such a case, if the thing is sold pursuant to that foreclosure, the mortgagee will have no further action against the purchaser to recover the unpaid balance. In short, the creditor, in case of a sale of personal property in installments, when he forecloses the chattel mortgage, is not entitled to recover the deficiency. Okay? Again, take note, that's only for sale of personal property in installments subject of a chattel mortgage. But if the chattel mortgage is just a normal chattel mortgage, then the creditor may recover the deficiency. Okay, now we just have to distinguish between a chattel mortgage and a pledge. Why? Because they both cover movable properties and they both secure a principal obligation. So it's very confusing which to use, no? Of course, they are covered by different rules. That's the first distinction. Okay? But in case of a chattel mortgage, there is no delivery of the thing. And in pledge, the thing must be delivered. Okay? There is no delivery in a chattel mortgage, meaning the mortgagor gets to enjoy his property. While in pledge, the thing itself must be delivered to the pledgee. Okay? In chattel mortgage, there is a requirement of registration, while in pledge, there is no such requirement. Okay? Also, a chattel mortgage has different rules when it comes to the sale of the thing, while in pledge, there are also different rules. Such as in the case of chattel mortgage, the excess in case of the sale goes to the debtor, whereas in a pledge, it does not. Okay? Of course, this is subject to exceptions, such as when the parties have stipulated that the debtor may receive the excess, or in case of legal pledge. But as a general rule, in a contract of pledge, the debtor is not entitled to the excess of the proceeds from the sale of the thing foreclosed. Finally, in a chattel mortgage, the creditor may sue for the deficiency. Okay, in case the sale is not enough to cover the principal obligation. Okay? Except, of course, 1484, which I discussed earlier, the recto law. Whereas in pledge, the creditor is not entitled to the deficiency. Okay? So that's it for chattel mortgage. I hope you have picked up a thing or two, and I hope to see you next time for my other videos. Okay? See you next time!